Good afternoon, everyone. Thank you for joining us for this very special event, a celebration of Life of a Showgirl, Taylor Swift's latest studio album. I'm sure some of you are Swifties. Those of you who are not might just be interested in intellectual property law. And we have three really exciting presentations today. My faculty, the UC St. Augustine Faculty of Law, is hosting this event, but we are most pleased to have two of our American colleagues, Professor Rachel Landy from Cardozo, Professor Rachel Dixon from Willamette School of Law, joining us here today. So thank you very much for being here. We have three presentations, and if I could ask non-presenters to please take off their cameras so you can focus on the presenters as well as the actual presentations. In terms of the structure, each presenter is going to go through their presentation and then there will be 10 minutes for questions. In terms of asking questions, you can either put your questions in the chat, which I will be monitoring, or you can raise your hand. So we will have time for questions after each presentation. So before we start, I'll just introduce myself. My name is Dr. Emma Perot. I'm a lecturer here at the Faculty of Law. I've been here since 2019 and I am a Swiftie. So I decided to have this event because I feel like there's a lot of interesting IP issues that come out of Taylor Swift's career. And it's also a fun way to learn law when you're looking at something you really care about. So I did go to the Eras tour in Lisbon, which was an amazing event. And now I'm excited today because I will be presenting with my colleague, Dr. Justin Koo, on leveraging the parasocial relationship of intellectual property rights. So we'll be talking about that. That is the final presentation for the day. So I'm going to start with handing it over to Professor Landy, who's going to talk about Taylor Swift and her masters and the re-recording. So Professor Landy, over to you.
Awesome. Thank you so much. And thanks everyone for being here. As Dr. Pro said, Rachel Landy, with an assistant professor of law at Cardozo Law School in New York City. And I hope everyone can see the slides here. I will be chatting a bit about how the law helped shape the Taylor's version projects. And to do that, we're going to have to look at two areas of law, a contract and copyright. But first, just a reminder about the context in which the Taylor's Versions albums came about. In 2015, at age 14, Taylor Swift was signed to a record deal. She signed with Big Machine Records, a Nashville country label. And she released several successful albums on Big Machine. I mean, classics, really, and here they all come. And in 2018, when that deal expired, she signed to a Universal Records subsidiary, Republic Records. But let's rewind real quick to that first Big Machine deal. What was in that deal? Well, as is typical in most record deals for new artists, Big Machine obtained ownership of the copyright in her masters, the sound recordings. And so, real quick, just taking another step back, there are two copyrights in each piece of music. We have the sound recording, which is what you hear when a song is played, and the underlying composition, the words and notes that are customarily reflected on a piece of sheet music. Two copyrights means there can be two sets of owners. And in the absence of a record label or any other intervening contractual arrangement, the artist would own the sound recording and a songwriter would own the composition. My evergreen illustrious example is the Beatles. I mean, take the song Let It Be. Assuming for a second no record labels involved, the Beatles, the band, would own the sound recording, but Lennon and McCartney would separately own the composition. We're going to put compositions aside for now and just talk about the sound recording. In a record deal, record labels typically obtain ownership over the sound recordings, which we do also call masters in the industry. So once again, all those albums recorded for Big Machine owned the masters. When Taylor signed to Universal years later, she had a lot of bargaining power at that time, having established herself as a wildly successful artist, and reportedly did not have to transfer ownership. But because Big Machine still owned the early records, they could transfer them just like any other asset. So they do. In 2019, Big Machine, the whole label, gets sold to a private equity group, Ithaca Holdings, which was owned by successful music manager Scooter Braun. Taylor and Scooter reportedly had some beef. Supposedly, she'd been trying to buy back her masters himself, but then Scooter flipped them over to another private equity firm, Shamrock Holdings, for about $300 million in 2020. She wasn't happy about that either. So that kind of covers how and why Taylor didn't own those original recordings. Now let's talk about the re-records. Well, to do that, once again, we have to go back to the original contract with Big Machine. So record deals frequently include what's called a re-record restriction. And they say that for a certain number of years, usually around 5 to 7 years after the original release, or some period of time after the contract expires, the artist can't re-record the same music. So I collect leaked record contracts just so I can show actual language in settings like this. And here's what it looked like in Kanye West's deal. And Kanye himself leaked his entire contract a few years ago. Now, these sorts of clauses are pretty standardized now. And where does the duration of that restriction come from? That 5 to 7 years or so? You'll see it's about 5 years after delivery to the label in the Kanye sample. Well, my hunch is that labels are worried about enforceability. I mean, these re-record restrictions are effectively like non-competes, and states like California and New York require non-competes be reasonable in scope, including with respect to duration. But you might be wondering, if they own the copyright, why would a record label need this? I mean, don't they have everything they need to reap all the rewards from the work? I mean, usually copyright prevents someone from making an exact or near exact copy of a work that's entitled to protection without a license. If I write a popular book, well, you can't copy the same book word for word or even mostly word for word without my permission, except in very limited circumstances, none of which are likely to apply to ordinary course commercial exploitation in the same market. If I transfer the copyright in that popular book to a book publisher such that they own the copyright, well, then I couldn't then copy the same book word for word without the publisher's permission. This is true for books, paintings, movies, television shows, but it is not true for sound recordings. So let's take a little detour into copyright history. Sound recordings were one of the last forms of commonly consumed commercialized creative works to get protection under copyright. They actually weren't incorporated into the act until the 1970s. And they were done so at the urging of the record labels who manufactured and distributed physical records. The label's business was fine when they controlled the entire supply of physical product and had their hand in every distribution chain. But as music began to move away from vinyl records and towards technology that could be more easily replicated, it's 8 tracks, tapes, CDs, the labels grew concerned about a bootleg market. They wanted to be able to go after people who copied their records onto a different or cheaper technology and then resold them without the label's permission and, of course, without sharing any of the profits. So labels got their wish. They got sound recordings protected under copyright for the first time in the early 70s, but with some limitations. Pretty much every other creative work protected under copyright gets what let's call the full suite of rights. There's some nuanced distinctions where it makes sense for the medium, but these rights are otherwise quite robust. Sound recordings, however, get a lesser set of rights in two meaningful ways, one of which is directly related to the re-records. I'll leave the other limitation that relates to what you see in the sixth right there to the side because it doesn't impact our discussion here, but of course, happy to take any questions on it. We're going to hone in on these two. So here's your little bit of actual law. Right here, buried in the Copyright Act, 17 USC 114B is the actual sounds clause. And it says that it's only a violation of the right to reproduce and create derivative works of an original work if the actual sounds of that original are copied. What that means in practice is that you need what I call a Control-C copy of the original to trigger an infringement of the reproduction right of a sound recording. It even says in the next sentence, that bottom excerpt, it actually really couldn't be clearer as far as legislative drafting goes. It doesn't matter if you have something that sounds similar. If the sounds are fixed independently of the original, there is no infringement. And this provision enables what we call sound-alikes. It's okay to create a sound recording that sounds very similar to a pre-existing sound recording, so long as either the composition is sufficiently different so as to be non-infringing or the composition has been licensed. And this just isn't true for other works. I gave the example of the copied book earlier, where if I sat down and copied a book word for word into a new document, I'd be infringing. For sound recordings, once again, you'd only get to infringement if you're hitting Control C on the original. No matter how similar the sound alike is to the original, it's not an infringement. So even though labels obtain ownership of the copyrights in the original masters via the record deal, the only way they can prevent an artist from re-recording is through contract. Copyright won't help them there. And from a business standpoint, labels are trying to prevent exactly what Taylor did, trying to prevent an artist from re-recording their earlier albums after getting out from under contract with the label. Why? Well, because the re-records might then undercut the revenue stream of the original. And so what we saw when the Taylor version records started dropping was her taking advantage of the re-record clause expiring. Again, those restrictions don't last forever. And we saw the kind of the drip and dribble of each album coming out. Reputation, of course, was never released, and from Taylor's statements, it sounds like it probably won't be. It would have been the last album to be subject to such a restriction because it was the last one created for Big Machine. Okay, so what are the consequences of this? From a copyright standpoint, none so far. If I was the record labels, and I'm definitely not, I'd be revisiting Section 114B, not because of Taylor, but because of AI. But I'll punt on that topic for another day and another project. But for artists, well, we don't have access to anyone's confidential record deal. As I said, I just wait for them to be leaked. But the reports are not great. Here's what Taylor said when she decided to embark on the Taylor version projects. I've pulled out a quote from her long Tumblr post, the don't know what else to do post. She wanted to do good for others. She said, I feel very strongly that sharing what is happening to me could change the awareness level for other artists and potentially help them avoid a similar fate. The message being sent to me is very clear. Basically, be a good little girl and shut up, or you'll be punished. So she said she wanted to do good for others too. Well, here's what has been reported. As far as anyone knows, labels have just gotten more aggressive. Perhaps they're less worried about the enforceability of a longer re-record provision so long as it acts as an effective deterrent to artists. As that last headline says, record companies are trying to keep artists now from re-recording for longer periods and in some cases ever again. So this is also a reminder. Anytime a new artist enters into a record deal, they typically do so with no more bargaining power than Taylor Swift did at age 14. And that means they don't get to negotiate these provisions. They take what's offered or they forfeit the opportunity to do the deal. What Taylor was able to accomplish for herself was as much a result of her conviction as it was her already established track record of success. They gave her both the resources and the megaphone to raise awareness. Newer artists just don't have that kind of power. Oh, and of course, the coda here is that Taylor was eventually able to purchase her original masters back, I think earlier this year for $300 million. So that's the background and what had to fall in place for her to be able to release the Taylor versions. And I'm happy to take some questions from there.
Right. Thank you very much for that, Professor Landy. So if anyone has questions, you can put them in the chat and then I will read them out, or you can raise your hand. So while waiting for people to think about questions, Professor Landy, so I'm thinking the longer re-record terms, as you mentioned, may not be reasonable. They might be struck down, particularly in states like California that don't like these longer non-competes. But you also said it might just be a deterrent. And I think that is a very important thing to recognize that new artists who are coming in who do not have the financial backing to have a very strong legal team on their side won't necessarily be the ones who are going to fight these things down. Whereas the more established artists, they might negotiate it out, but they already have that backing, they already have that power. So again, it's always going to be those at the beginning of their careers who just don't have the power. I see a question in the chat from John Tandy. Why is the Control C rule for music only?
Um, I think the short version is that actual sounds provision was incorporated into the act when sound recordings were given protection. They were done at the same time. So, books, movies, all these other kinds of works, visual arts, they were already protected by copyright. That was already an existing regime. And when they incorporated sound recordings into the act, they also incorporated the sound alike restriction, or the actual sounds restriction. And I think the idea was actually we wanted to encourage not necessarily sound alikes, or maybe I should say we wanted to discourage frivolous infringement claims from songs that just simply sounded alike. We didn't want the incorporation of the sound recording right to suddenly give rise to a flurry of infringement claims just because two songs sounded similar. And so that I think is how we ended up there. But it is unique to sound recordings.
And we have a question from Professor Liebsman. Hi, Yvette. Thank you for coming. Does the erosion of the gatekeeper system, the ability of musicians, songwriters to make quality recordings and sell their work independently, is this another reason for record labels trying even harder to keep as much as they can for as long as they can?
Um, I think the labels would say that they need that with everything going on, that there are easier paths to independent distribution, that they do need stronger rights as a result. I sincerely think that's what the label would say. They're making the investment up front, usually on the recordings, and they need to be able to ensure they can recoup all their costs and then generate a profit so they can continue investing in new artists and new works. Now, you may sense a bit of snark and skepticism in my tone. Record labels have certainly on like just basic dollar figures never been doing better. The CEO of Universal Records got like a $120 million pay package a couple years ago. Their revenues adjusted for inflation are almost back to where they were before Napster, before file sharing. So, I don't know how much more labels need, but again, they would tell you differently, and it always goes back to they have all the leverage at the bargaining table.
We have a question from Andres Rodriguez. Have courts defined what recapture the actual sounds means? How much does the song need to be a sound alike to be non-infringement?
I'm not aware personally of any ruling on that particular issue. It's a great question. I do know the Copyright Office has grappled with this in registration applications for songs years ago, and you can find it online. There was a registration application. This is, I mean, way before AI, but someone had developed their own kind of version of AI, early version of AI technology that was able to make near exact replications of songs, not using the actual sounds. And they ended up denying the application on originality bases. You have to clear a certain threshold to get copyright protection of anything, and that threshold largely depends on originality. And if what you're submitting for registration sounds exactly like down to the note of something else, just because it's not infringing does not mean you get protection. But I'm not aware of any litigation over the actual sounds provision, but it's a great question and certainly something that is worthy of looking into to see what courts have opined on.
Yeah, I was thinking about that as well because in one of your news clippings, Taylor Swift was talking about she's being threatened that she cannot perform some of the songs because they're alleging that would be a re-recording. I did wonder, is that really going to be a re-recording? Because the performance elements usually add a lot. It's not really going to sound just like what you hear when you're streaming the song. So to me, that was a quite a serious threat, but one that I do not think has a sound legal basis in it.
Especially because she's the songwriter. And so from the composition standpoint, she's on pretty solid footing. So yeah, that seems to me like a bit of an empty threat.
But again, the threats are what made the whole thing blow up. So I guess in a way, it was effective.
Yeah.
So our co-speaker, Professor Dixon, asks, do we know yet if Taylor's re-recording project has had an impact on how new recording contracts are being drafted?
I think that's just all we really know is that kind of last headline I put up, which is that all reports suggest the labels have just taken a much more aggressive approach to contracts with new and up and coming artists.
Okay, and on the theme of contracts, my dean, Professor Elias Roberts, Dr. Elias Roberts, says given cases like Taylor Swift's early recording contract, which appear to be unfair or exploitative and limit her control over her own work, do you think that current contract law provides sufficient protection for emerging artists who often lack bargaining power? To what extent can doctrines such as unconscionability or unequal bargaining power be used to challenge such contracts? Or is there a need for more specific legislative safeguards in the entertainment industry?
I love this question. I do not think that the law currently provides sufficient protection for emerging artists. I think they're often taken advantage of. However, and I actually have an article about this exact issue. I advocate actually for better unionization among featured recording artists, akin to what you see in the film, television, screenwriting, directing industries for collective bargaining. I think that provides the most I guess like the strongest path to getting more rights, especially as new technologies come into the industry, the labels end up controlling how those technologies use creative works, how they're compensated, and so forth. And we saw this with streaming and the advent of the streaming services. The labels set the terms that now basically every streaming service operates under in their license deals. And we're seeing it with AI as well. I will probably still be waiting a little bit for some of the big litigation to get flushed out. But without a doubt, the record labels have already started thinking about how they want to license AI. And the only way to really get artist involvement in that is for them to come to the bargaining table with some force. And I think that comes from coming collectively rather than on their own, especially because, contract law in the States is state by state. And so that it can be somewhat easy to kind of try and arbitrage around that, depending on where people are and where they're contracting. California has a long history of trying to protect entertainers from exploitative contracts with the 7-year limit on personal service contracts and whatnot. But nevertheless, that's still a long time to be stuck in a bad deal. So I think there's a lot more the law could be doing here.
Nice. I think that's a really practical perspective. Can you tell us, is the article published and where we can find it?
Well, it's on my SSRN page, and it'll be coming out in the Boston University law review, and it's called Did Copyright Fail Artists?
All right, excellent. So that's very much on the topic. So, as Professor Landy said, check out her SSRN page for that forthcoming article that gives us a very practical viewpoint. And I see some more questions in the chat. So, from Candace Brathwaite, can it be argued that Taylor, as a young entrepreneur, did not have the capacity to estimate the potential value of her estate, and that the real value only became apparent after the investment and appreciation of her empire?
Absolutely. And that's what I mean, the labels would say absolutely. We are the reason that she became so big and famous, and we contributed all the value. I think if you are listening to the album and you take a very, very close ear to one of the songs, she's actually taking a lot of jabs at that specifically. And the founder of Big Machine. Uh, and so that is always the push and pull here with the record labels and new artists. And in hindsight, like who really helped who it can be hard to find that line.
We have another question from Pina Bakitas. Thank you for the great presentation. What would be an acceptable duration for the re-recording restriction in practice? What factors would play in deciding a reasonable duration or clause?
So I think from a legal perspective, in terms of what is reasonable, so state law is going to inform a lot of that. I suspect that industry custom has landed on 5 to 7 years because they took a survey of state law and found that that would be pretty sound footing to stay on. What's interesting here now is with streaming, we have what's called the long tail catalog albums that get a lot and lot of usage years and years after they may have been released. And so, put Taylor's version aside, it's actually not terribly surprising to me that labels want to see longer restrictions because we never know when some song, I don't know if you remember, like when the Fleetwood Mac song became like super viral a few years ago because it was in the TikTok video. Like that song is decades old. And so you see a lot of these older catalog tracks like seeing resurgence and all of a sudden becoming very popular and in the mainstream again. So even though I suspect like 5 to 7 years is probably reasonable under law, I am also not at all surprised that the labels want more.
Okay. And we have a question from Zuriel PN. Great presentation. Could producing a live album be viewed as a lawful form of self-reclamation of one's sound recordings? Or would labels argue it's an indirect breach of a re-recording restriction? Essentially, do you think live albums fall within a gray area, or is the composition sufficiently different?
Uh, I suspect that the re-record restriction in the contract probably would be read to apply to live albums, that they can just handle that via contract and they would. Um, and so there's no way that just releasing a live album um would would be an end run around the restriction.
Suspected. They haven't said it yet. It's very much going to be there very soon, based on everything we have seen.
Mhm.
Okay, from Godwin Owusu, great presentation. What do you think is the practical effect of the termination of assignment clause in the Copyright Act? How can artists take advantage of that in order to regain control over their masters?
Another great question. I write about this in the article I mentioned. So under the US Copyright Act, artists have, or excuse me, authors, people who create works, have the opportunity to transfer assignments of those works 35 years after the date of the transfer. There is a really, really important carve out to the termination right, however, and that is when a work is deemed made for hire. It is a work made for hire for usually an enterprise or an organization or a corporation. In that case, the termination right doesn't exist. So it probably won't surprise you to learn that in record deals, historically, record labels say all the recordings done under that contract are works made for hire, and therefore there is no termination right. It's only usually when an artist has more or better bargaining power, better legal counsel, and what have you, that they're able to negotiate for a transfer of ownership or an exclusive license to a label that would give them a termination right 35 years into the future. Almost certainly, Big Machine got ownership of the masters as works made for hire when Taylor signed to Republic, and she kept ownership. As far as anyone knows, she likely granted an exclusive license, which would be terminable.
All
There are
right.
a lot of wrinkles, a lot of interlocking sections of the Copyright Act in this ecosystem.
Yeah, definitely. And I'd also like to remind people, because I know some of my IP students are here, that we're currently discussing US copyright law. And as my trainee students and other curriculum students know, we have different takes on some of these provisions. So please keep that in mind for your exam. And we have one more presentation before we go over to Professor Dixon. So great presentation. Thank you. Would the same re-recording strategy hold up under Caribbean or Commonwealth IP frameworks, or are the protections weak or strong compared to the US? Well, I guess that's a question for me or Dr. Koo.
I'm going to
I,
let you take that one.
I'll direct it to Dr. Koo because his specialty is copyright law. So Dr. Koo, do you want to answer this one? He's also research on music
Yeah,
copyrights. I feel he's best placed.
that's that's a good question. And I think it comes back to what Professor Landy just discussed about the works for hire doctrine, which we don't have in the context of the Commonwealth Caribbean. So it's really going to depend on the employment works provision in your various countries. If you take this from a Jamaican perspective, this doesn't fly at all because there's no way other than the contract expressly dictating ownership by the label. So when the author, the performer, the artist, etc., creates the work, they are going to have to assign that form formally, so in writing, through a separate contract, arguably, to the record label. In the context of Trinidad and Tobago, this would apply in an employment situation, and works for hire is much broader than just an employer-employee situation. There's no commission works provision in Trinidad. Barbados has a commission works provision, so it's really going to be dependent on the territory that we're looking at. I don't think framing it in the perspective of, I just want to see how the question is phrased again. So, work for hire clash with provision. Oh, sorry, that's the wrong question. Are they weaker or stronger? I don't think it's a matter of weak or strong. Is it a pro-author or pro-owner approach? And historically, the copyright law in the Caribbean, stemming from the copyright law in the UK, tends to be pro-owner. But there's some carve-outs in the context of the Commonwealth Caribbean. So I don't think strong and weak is really the way to think about it. It's whether it's pro-author or pro-owner in the context of employment works. So it's really jurisdiction dependent.
All right. Thank you for that, Dr. Koo, and thank you, Professor Landy, for your excellent presentation, which people are very interested in. We got a lot of great questions. So now we're going to switch over to Professor Dixon, and she is going to be talking about trademark law. So we're going from copyright to trademarks.
Yes, thank you so very much. Let me share my screen real quick and get this show on the road. All right. Are y'all able to see my slides without my notes?
So if you could put it on the full screen mode, we're not on that currently.
Okay. All right. Is that good?
Yes. Okay. Excellent.
Awesome. Thank you so much. All right. Hello, y'all. My name is Rachel Dixon. I am an assistant professor of law at William University School of Law. I am a former trademark examiner at the USPTO. I attended the Hamburg Eras Tour show, and I have talked enough about Taylor Swift with Dr. Perot and Dr. Koo that I was invited to this, which is so awesome. So the title of this, I'll Sue You If You Step on My IP, is obviously a tip of the hat to the original line of I'll sue you if you step on my lawn from Who's Afraid of Little Old Me. In the original version, this was not an actual threat. It's stated in the bridge as something people say about Taylor Swift, and I'm using it here similarly, as I found that actually Taylor Swift really doesn't sue people very often, and her enforcement efforts are generally pretty constrained overall. To get into things, I am focusing on Taylor's trademarks because although she also has plenty of copyrights, obviously, I found that the vast majority of the unofficial Taylor Swift merch I've seen on Etsy really implicates her trademarks, honestly, more than her copyrights. So I'm focusing on that. Her trademark portfolio is owned by TAS Rights Management LLC, named for Taylor Allison Swift. I'm focusing on records at the USPTO. There are over 300 total trademark records there. 161 of those are live and registered, 14 are pending, and 134 are dead. Some of those are registered, some didn't. A dead mark cannot be enforced right-wise as a registration. And there are a number of categories, which I'll get into shortly. These records are, these marks are registered with a wide variety of merchandise in 18 separate international classes of goods and services all across the spectrum. The most common merch seems to be clothing in class 25, but as you'll see, she has everything from soap, jewelry, guitar picks, posters, pillows, blankets, you name it, it's up there. By far, the most registrations and applications she's had are for her album names, and then there's quite a bit for her identity / cats, and we'll talk about some of these other ones as we go. I've also organized these by how many of them are alive versus how many are dead, just to provide a comparison. In this first category, albums, this includes album names, album references, and events, such as Midnight's Mayhem with Me was events leading up to the album Midnights, and then album abbreviations. One critique that people have made is that people are making fan merch because there's not enough good merch in her official store. So I'll be doing a comparison throughout this presentation of what is available officially and what is available on Etsy. I'm focusing on Etsy because it's easier to search than Instagram and TikTok marketplaces, to be completely honest. But you'll see there's both the official store and Etsy have plenty of merch for the album names. Throughout, I'll be talking about different trademark strategies as well. We can see in Taylor's portfolio. Trademark filing timing is often very strategic, as applications to register trademarks at the USPTO are publicly viewable within a few days of filing. Sometimes artists choose to file immediately before or after an announcement to avoid spoiling the news, as the news absolutely knows about this and reports on this all the time. In her early eras, there didn't appear to be a particular timing strategy. Some were actually filed significantly after the album's release, sometimes years later. And there were actually no trademarks ever filed for the album Red until 2021 when it was Red Taylor's version. But in the years since, albums have become filed much more strategically. Folklore, Evermore at Midnights, and Tortured Poets Department were all filed on the same day they were announced. Life of a Showgirl was filed 2 days before announcement. This seems to be the standard now to sort of secure rights quickly, but avoid giving away the surprise. Next category, we have identity and cats. I threw the cats in here because I didn't really know where else they went in. But you've got, Taylor Swift's name, last name, initials, and her cats. There's a fair amount of merch in both official and Etsy stores for this. Couldn't find any current cat merch, so I had to dig into the trademark application records a little for the official merch on there. Most of Taylor's official merch using TS or her name are also combined with other marks like album names or song lyrics. It can be a little difficult to find fan merch on Etsy that actually has Taylor Swift's full name in it. I think she enforces that pretty strictly, as we'll talk about a little more later. I wanted to point out something really smart Taylor's team does. Technically, the use of wording on a shirt front is not actually trademark source indicating use. Your average consumer seeing wording on a shirt is not going to look at that and be like, oh, that's the source of the shirt. So that's considered ornamental use. And the USPTO isn't supposed to really accept t-shirt specimens with just wording on its front for showing trademark use. But they consistently put her trademarks in the label area of a shirt as well, which is very standard source indicating spots. And that's just really smart for her team. Next, we have tours and events. This had the highest percentage of Denmarks because, of course, merch using specific tour trademarks just aren't as in demand once the tour is over. It's inherently time limited. This category does include some planned tours that never happened, like Loverfest. The only official merch I could find at this point is the Eras Tour. Etsy merch is mostly like the Eras Tour. And there isn't a ton of other tours there because, again, it's like sort of an inherently limited time of demand. Moving into songs, a lot of the song apps have died. And by songs, I mean both song names, lyrics, and lyric abbreviations. These are mostly from 1989 or Reputation. There's one song named from Lover and another from a Christmas single. And there's a fair amount of official merch on both the official store and the Etsy store. Going back to what I was saying about ornamental trademark issues, showing use of song lyrics as trademarks can be a little tricky. These are all things from the trademark application records for Taylor's marks. So like a consumer might not look at this phone and see that like, oh, the song lyrics are a source indicator, but they have the name in the listing where you can buy it online. So that's pretty standard for that. And then there's some other ones that are much more fishy. This sticker sheet in the upper right is supposed to be the specimen for Because We Never Go Out of Style, which is one of like 8 different song names on that sticker. I cannot believe that was accepted, actually. But yeah, these are sort of some examples of the things we had here for that. A fair amount of Taylor's song lyric marks particularly have come under criticism. Around 1989 and Reputation, there was quite a lot of public criticism around her trying to register as trademarks blank space, this sick beat, shake it off, things like that. And she appeared to notice this and switch tactics. She has not applied to register any song lyrics as trademarks since Reputation, even though she has quite a lot of merch that features various song lyrics and song names on them. None of these are registered or applied for as trademarks. She's very aware of her PR and she switched tactics to avoid that being a thing again. This next category is interesting because I believe these are mostly relating to her app. She had an app called The Swift Life that launched in December 2017 and was discontinued entirely in February 2019. There are several other applications in here that never came to fruition. We don't know exactly what they were for, but based on context, I'm guessing they were supposed to be for the app. There's no merch relating to this at all. I threw in a couple photos of showing how these things were used in the app when it was available. But no one seems to really miss the app, either Taylor or the fans, because no one's making merch around it. I did want to point out these trademarks, for the most part, were filed in a sort of secret roundabout way to avoid publicity, I'm guessing. One of an attorney who's actually represented Taylor in the past, Jesse P. Chaudhry Jr., was the principal of Cobalt Canyon LLC, who originally filed all these marks in January 2017, and then they were all assigned to assigned to Taylor in December 2017. So this was all likely a tactic just to keep their filing secret, sort of keep the plan hidden until they were ready to have that out there. There are also some trademark registrations and apps for Swiftie and Swifties and Taylor Nation. Not a ton of official merch around here, but a fair amount on Etsy. And then this sort of final miscellaneous category includes Female Rage the Musical, which was rather famously filed the day after Taylor Swift first made a joke that the Tortured Boys Department section was called Female Rage the Musical on the Eras Tour. And then she also has an app, multiple apps actually over the years, for A Girl Named Girl, which is the name of a book she wrote when she was a child. And I'll talk about that more in a second. There's no official merch for either of these, but Female Rage the Musical is very popular on Etsy. The Girl Named Girl apps were, the first one was filed on an intent to use basis back in 2015. You can, if it's like kind of extend your time to show use pretty far. And basically right before that was about to abandon in 2020, they filed a new app and have done that again since. So they're basically stacking intent to use apps to try to protect A Girl Named Girl as long as possible without her actually taking action to show the use. So that's an interesting tactic. Also wanted to point out, pretty clearly Taylor's trademark strategy has inspired her fiance Travis Kelce as well. Although he did have a few applications before they started dating, he notably filed for 5 new ones a couple months after they did start dating. And there's truly a hilarious amount of fan-made merch celebrating Travis and Taylor's relationship at this point. Super fun to just like scroll through Etsy looking at it. One final thing, there are Jack Leopards and the Dolphin Club merch on the official store. This was actually a fake band made up of Taylor Swift, her brother, and Jack Antonoff, her longtime collaborator. This was formed only to cover one song, which was featured in the TV show Killing Eve, to make sure that Big Machine Records would not receive royalties from the song's use, for all the reasons my co-presenter just mentioned. And it's held by a different entity. It's held by 311 LC, which also owns 2 applications for Austin Swift, Taylor Swift's brother's name. Anyway, moving on to enforcement. Why do you actually have to enforce? This is a requirement. You have to enforce your trademark rights against infringers in order to maintain them. Under the doctrine of laches, if a plaintiff delays bringing an action for such a long period of time that the defendant party has been prejudiced, the claim is barred. And the famous description of this is those who sleep on their rights lose them. So of course I've included pictures of Taylor Swift's cat to illustrate the doctrine of laches effectively. Taylor has enforced, but honestly not as much as you might think given some of like the reputation. TAS Rights Management has filed extensions of time to oppose applications at the TTAB twice in situations where they ultimately did not oppose the marks. And these ended up applying, this happened with Swiftly for a social networking app and Speak Now for a natural language processing app. These both ended up registering. And this kind of indicates that Taylor's trademark team really does consider its oppositions carefully and is not overly litigious. They took the time to really look at these, but ultimately didn't oppose them and let them move forward. There have been 2 other times where oppositions were pursued to their full extent at the TTAB. Swiftie for graphic design, computer programming, and other services was posed for on a 2A false connection basis based on registrations for Swiftie and Swifties. In this case, the applicant never responded. Default judgment was handed down and the app was refused registration. Taylor Talk was also actually registered before the opposition was filed. And that was for a podcast that actually was about Taylor Swift. And this podcast was going on for a very long time. I believe it started in around 2008, perhaps, because I think they hit a 10-year anniversary before they really stopped updating. And they opposed the registration. The registrant never responded. default judgment was entered and the registration was canceled. But I should note that podcast is still very much up online. You can absolutely go and listen to the old episodes. They simply weren't allowed to keep the trademark registration for it. So this is definitely a situation where, like, if she had wanted to really push her rights, she could have tried to push them further, but she didn't. In court, I was only actually able to find one filed trademark infringement case. There may be more that I just haven't found. But this is the one I found. It was filed in 2016 in the Middle District of Tennessee. Apparently, there were like 45 different people selling counterfeit Taylor Swift and 1989 World Tour merch around the stadium where she had the tour in, I think it was 2015. Default judgment was entered against them, but it ended up just being a permanent injunction. Basically, you can't manufacture or distribute or sell any of these things anymore. But there were no monetary damages, and that seems to really align with general practice of like not really pursuing money damages or harsh remedies, just wanting people to stop. There may be more that I don't know about. I did find at least one law firm that advertises their ability to defend people against Taylor Swift IP claims. He seemed to think there were a lot more out there than I found. Moving into sort of the Etsy enforcement conversation. This is all really relevant because official merch is very big money. The Eras Tour, we know for a fact, this was confirmed, made over $2 billion in ticket sales, which is the highest grossing tour of all time. Merch, we don't actually know. There are a number of different estimates. The one I think is probably more realistic, if the numbers are right, you can guess around $496 million in additional merchandise revenue for the entire tour. There are many other revenue estimates, including one that estimated it as $2 billion, which I do think is unreasonable. But regardless, this is a very high number. Taylor Swift was making absolute bank on merch from the Eras Tour. And this also happened with Etsy sellers as well, people selling fan-made merch. There were some that reported making over $15,000 in 2023 just from selling friendship bracelets. Over $3 million, about $3 million in friendship bracelets were sold on Etsy in 6 months in 2023. This is just an example of her economic impact, of course, because the friendship bracelet popularity really is attributable to the Eras Tour. And in November 2023, there were over 175,000 Taylor Swift items for sale on Etsy. Etsy has sadly disabled the feature where you can see how many items were listed under a search term, so I can't tell you what that amount is now, but it is quite large. So I had way less data and information on the takedown stuff than I thought I might when I first pitched this. So I've had to come to like get creative in figuring out how often these takedowns are happening. I know there were reports of some takedown notices being sent to a few sellers via Etsy in 2013. In 2015, there were several news articles published about takedown notices, and many of these were really very critical of Taylor Swift, and they were also intertwined with some of the criticism over her trademark registration of some of her song lyrics. And like they noticed that like things that have been listed in Taylor Swift gift lists on BuzzFeed, only 3 out of 15 remained online at that point. Looking through news reports, I actually couldn't find news reports of takedowns between 2015 and 2024, which I know is a really big jump. And obviously, there must have been some takedowns happening during that time, but apparently wasn't high enough to really get news articles written about it. I do want to research this more in the future. So, like my initial hypothesis was that I assumed she was like, due to the prior bad press, not really doing takedowns anymore. But I was clearly wrong because she's absolutely been doing a lot of Etsy takedowns in the last 2 years. The reports of them happening in February 2024, reports of more enforcement this year. I went through and did sort of an unofficial audit of quite a few, like of the articles that came out in 2023 and 2024 of like, here are the best Etsy Taylor Swift fan merch. And quite a lot of them have had their shop shut down. There was an article that specifically focused on people who are now making full-time money with Taylor Swift merch. All of them had their shop shut down or completely emptied of Taylor Swift merch. And then 23 of 29 Etsy listings in a June 2024 article on Taylor Swift fan merch have been taken down. Others were still up but sold out, so you can kind of tell the difference between one that's just out of stock versus, oh, this was actually taken down. Also of interest, there's a tagging system on Etsy, and the URLs basically you can kind of fill in a tag, and if something no one has used as a tag, it just searches the website automatically. But there are a few people who have appear to have had their names completely blocked as tags. Only a few though. I could only find this for Taylor Swift, Beyonce, and Drake. So people have had to get creative with they use some Taylor tags, they use some Swiftie tags. There's a lot of misspelled Taylor Swift type tags. It's really interesting seeing how they get around it. So for conclusions, it's a little hard to tell what merch can be sold on Etsy because the takedowns do seem to be sometimes all over the place. It does seem that they do focus heavily on items with Taylor's full name or likeness on them, so I would definitely avoid having Taylor Swift on merch there. Merch that uses art from her album covers is likely to implicate both trademark and copyright registration, so that'd be good to stay up front. If you use work as inspiration rather than directly copying, it's likely got a better chance of staying up, but also it's hard to estimate. Anyway, that is my conclusion. Thanks y'all so much. Here's some photos of me at the Eras Tour with my Trademarks Taylor's Version shirt for your.
Thank you so much for that, Professor Dixon. So we have a question in the chat. Great presentation so far. This is from Ronnie Yearwood. My question is, do you believe that Taylor Swift's IP strategy should be used as a benchmark, offering owners of IP assets the legal foresight in protecting your brand, vision, and commercial IP protection?
Yes, that's a really good question. I think you can take an awful lot of lessons from her IP strategy. I mean, what works for Taylor Swift may not work exactly for other people just because she's just at a whole nother level of popularity. For smaller bands in particular, perhaps they really need those merch sales from their concerts. So maybe it doesn't benefit them to have fan merch out there that other people are making in the same way that it would Taylor Swift. Although there's also an argument to be made that fan merch just increases your popularity. But yeah, I mean, there's definitely a lot of strategies she uses that can be useful. It would just have to be, I think a lot of these enforcement decisions are just really based on an individual IP owner's goals and would have to be very case by case basis.
Okay, and in terms of the enforcement, so this is my question. I know a lot of the news focuses obviously on the US, which makes sense in terms of the language barriers and whatnot. But a lot of these trademarks are registered all over the world. As we know, trademarks are territorial. Have you come across anything in your research about her enforcing in any other jurisdictions, or is the news that you've seen mainly US focused?
The news I've seen is mostly US focused. I know she has international trademarks and I know she's enforced overseas, but it was not as sort of that would be a whole other presentation that I'd love to do.
Of course, yeah. I'm just wondering if she maybe has even a stronger enforcement approach in the US, and maybe I wonder if she's taking it as strongly in other jurisdictions. So next presentation might be on that comparative.
More research needed.
More research needed on that one.
Yeah, multiple papers.
Yes. In terms of the trademarks that have been allowed to die, did you see any reasons as to why that might be the situation? So why would you decide to keep some alive and allow some to die?
Well, for some, it just seemed like she didn't maybe need them anymore. Like the tour marks, most of the tour marks have died because I don't think she's selling reputation tour merch anymore. Just because it's just not something she's doing because that was 8 years ago. Some of them seem to be just sort of switch in strategy, the apps that seem to be associated with the software app that's ended up dying. For some of them, I think a lot of the song lyric apps were allowed to die because she just realized how unpopular they were. So probably it just varies. I think changing strategies, changing approaches to keeping that parasocial relationship, which y'all are going to talk about so much.
Yeah, so we're definitely going to touch on that in terms of maybe you don't enforce all the time. Just a note in the chat. So yes, somebody asked if this will be available. There will be a recording of this because our presenters have both consented to being recorded, and as well as my colleague. There'll be a recording of this posted on the UW St. Augustine Faculty of Law YouTube page. There is no special sign-on or anything, so once it's available, you just go on the YouTube page and you will see it there. So yeah, anybody who wants to look at this subsequently can feel free to just check out our YouTube page. Do we have any other questions for Professor Dixon before we go on to the parasocial relationship? Let me just make sure I'm on top of the chat. Okay, so just nice compliments in the chat, which is great. I
Always
have
appreciate it.
one final question for you, Professor Dixon, in terms of the cost of filing trademarks in the US, since we're talking about the US context. Can you give us the idea of what a cost might be for a filing of a basic trademark for just one class? Let's think about how much he's spending on this, because obviously there's a lot of money being spent, but what's just the basic cost we can think about?
Sure. I'm double checking my numbers real quick because I just changed them earlier this year. Um, so it ends up being currently per class of goods and services. Like I showed that list of them. It's $350 per class, and basically all her apps have multiple classes. I think there might be one or two that's one class, but the vast majority of them have 4+ classes. So that's pretty pretty significant investment on that side. And then of course you're looking for attorney's fees for filing all these things and doing all the back and forth with the examiners as needed.
Okay, so this is not going to be a cheap thing to do. So again, just like the issue with the re-recording, the more powerful you get, the more resources you have to do this. But it would be a little difficult to go broad when you are just starting out. Although it might not be as necessary when you're just starting out as well, unless you go through the argument that you need this fan merch, which you can still, suppose, limit your registrations for. So thank you so much for that, Professor Dixon. We've seen that there are a host of trademarks for lots of different things. And I found the cat trademarks particularly interesting in terms of how her identity is now encompassing her pets as well, and how she is able to protect that. So now I'm going to ask Dr. Koo to introduce himself while I put up our slides for our joint presentation.
Hi, everyone. Good afternoon. I am Dr. Justin Koo. I'm a senior lecturer here at the Faculty of Law, UW St. Augustine. I am a Swiftie. You can see I'm wearing my Swiftie shirt from the Eras tour, where I attended in Lisbon as well. So I want to talk a little bit about the background to this paper, how we got here, and then we'll get into the actual stuff about the law and things like that.
Right, so Dr. Koo, can you just confirm that you're seeing the slides properly?
Yes, we're seeing it.
Great.
Yeah. So how did we get to this paper? To be honest, at the beginning, I didn't have a clue about what parasocial relationship meant or anything like that. I'm an intellectual property person, copyright, trademarks, that's my forte. But just looking at the growth of Taylor Swift, the growth of her business empire, there's no way that intellectual property rights become so popular just by virtue of the inherent value in the music. So what we'll talk about today is Taylor Swift's intellectual property portfolio and then the growth of that using the parasocial relationship. But what I want to focus on in terms of how we started this paper is really interrogating that question. What separates a Taylor Swift from your average performer, your average artist, your average copyright author? Because Taylor Swift is now a billionaire, probably the richest artist in the world. Very few artists get up to that level, and I think Taylor Swift, especially post Eras tour, has gone way past any other performing artist in that regard. So, in doing some preliminary research, and it was actually Dr. Perot that brought this discussion of the parasocial relationship into it, and then we had a discussion about it, and then we're like, oh no, we absolutely need to write this paper because I think the parasocial relationship is really the root of the growth pattern that led to Taylor Swift being so super successful. So by way of structure, we're going to talk about the bidirectional parasocial relationship, which is a slightly evolved form of the typical parasocial relationship. We'll talk about Taylor Swift's intellectual property rights in particular, focusing on her copyright, trademarks, and her persona rights. We'll then talk about the different types of disciplines that feature in this parasocial relationship, because the idea of the parasocial relationship is not something that is found in the law per se. When we talk about trademarks, we talk about the communication function. We'll also look at cultural studies, and we look at some other literature coming out of marketing research. So we have this interdisciplinary approach because eventually what you had happening is that meaning, or the concept of meaning and how we interpret meaning, especially from a celebrity or coming from a celebrity, have converged in the context of this Taylor Swift discussion. So that's a really interesting concept that we want to explore with you in more detail. The paper is published, and you can get it off of the SSRN on my SSRN. So you can feel free to download the preprint version of the copy there. So getting directly into the presentation, Emma will take you through the parasocial relationship.
So, parasocial relationship is a term which was developed in the literature in 1956 by Horton and Wall in relation to TV hosts. So, we're going back in time now. TV hosts with their night shows, which were showing on TV, which we can now see on YouTube and whatnot, used to try to engage the audience in a similar fashion that TV hosts do now. So, all these late night hosts, they will have different activities and whatnot. Back in the day, they would do things like read fan mail, which was obviously in the form of letters, because we're talking about 1956. They would also talk to the audience and get stories about them. So they'd have all these different interactions. They'd also show part of their personality to make the audience, both at home and in the live studio, feel like they really know this person. But of course, you can't really know someone if there's not reciprocity. You don't actually go out with these people. You're not actually communicating with them back and forth. It's very much one-sided. So the original parasocial relationship was conceived of this one-sided relationship where the fans are being made to feel that they know the celebrity in as much as they could, because it is a one-sided relationship. Fast forwarding now to the 2010s, we have the rise of social media. So we have TikTok and Instagram, which is quite different from the previous social media, including High Five, MySpace, all those types of things, because TikTok and Instagram allow for a higher level of interaction. Now, while these types of social media are often controlled by a manager or a content team, they do allow the celebrity to have a bit more direct access if they choose to do so. And even later than that, when Instagram Live was launched, sometimes celebrities would use this and post just a random live about what they were doing in their day. Because social media allowed for a new level of interaction, the relationship then resulted in a feedback loop. So the celebrities had a bit more of an idea of what their fans were expecting from them, what their fans were feeling. And in turn, they were able to feed into this. And fans, of course, now had a way to interact with each other. So unlike in 1956, where you're probably just interacting with your neighbors, your colleagues, now on social media, you're able to see other fans, interact with them. You might be on the Reddit website in a certain chat about your favorite celebrity. So there's a lot more interaction with people who don't even know each other. So as a result, we've now formed the bi-directional parasocial relationship. It is still parasocial in that you cannot truly know Taylor Swift. As much as I would like to think I did as a fan, obviously I do not know this woman. She is, of course, representing certain values that I now align with. I love her music. I want the merch and all that, but I can't know this person in the same way that you know an actual friend. However, me, being one of just many fans, is able to feed into this bi-directional relationship because she does have this kind of relationship with her fans where she is quite responsive. So in terms of examples of the bi-directional parasocial relationship and recent success, in terms of the Eras tour in particular, anyone who attended or even just following the news will know that friendship bracelets were very, very popular. Now, this trend of making and exchanging friendship bracelets came out of a line from You're On Your Own Kid, one of the songs from Midnights with friendship bracelets, so just reference in passing. Fans took this line and decided, let's make these friendship bracelets and exchange them, and then let's wear them in public as well, because people who understand Taylor Swift will then know that, oh, this is a Taylor Swift fan. And of course, that was very much embraced as a fun thing to do in attending the tour. In addition to that, the Taylor Swift Eras tour featured different eras of her music, and we saw those various album artworks on Professor Landy's slides at the beginning. Each of those pieces of artwork had Taylor Swift in a different outfit, and there was a different vibe for each album. So as a result, fans started to dress in their favorite Taylor Swift era, which means if you went to a concert and you're looking at how somebody's dressed, you'll say, oh, yeah, that's the Reputation era, or she's clearly into the Red era, or that's the 1989 era. Because the fans are able to communicate this messaging with each other just by how they look. And of course, Taylor Swift supported this. This was very much embraced as, yeah, come as your favorite era. So the fans now are, in fact, doing the marketing for her, which she is supporting by encouraging these types of trends. So the bidirectional relationship really involves the feedback loop that is being formed between fans and the celebrity. And that feedback loop just really was not that possible before we had modern social media.
So the key question here from the IP perspective is how does Taylor Swift leverage or manifest that feedback loop? And in order to do that, we need to look at the two elements of her intellectual property portfolio. So she has a primary intellectual property portfolio, which focuses on her music. So that's the songs, the lyrics, the actual music that she's recorded. So that includes her song recordings, the performances of that, the music videos that accompany it. There's also the secondary IP portfolio focusing on the trademarks and the rights of publicity. So when we think about the copyright portfolio, this is the main bit, right? Because none of this happens, this feedback loop, this bidirectional parasocial relationship, none of this happens without the music. So you really do have to be a successful artist, a successful musician, composer, performer, etc., to be able to leverage this parasocial relationship to get to the level that Taylor Swift has. So this is not something that's going to be available to all musicians, to all artists, etc. You have to be a successful artist in the first place. So it has to come together. But having said that, we see Taylor Swift from the very early days, and maybe it was not necessarily consciously done at the beginning, but over time, you can absolutely see that this was a conscious decision about how she wrote her songs, how she portrays the music in the music videos, her performances, the stories that she chooses to tell in her music. If you really think about her music is like an open diary for fans to engage with. And that's something that she's definitely not the first to do it, but she's the first to do it in this sort of modern era in the way that it's done with reference to the parasocial relationship. And why do I say that? When we listen to Taylor Swift's music, we know all of her problems. We know all of her challenges. We know that there are very clear themes coming out from her music. This idea that she's a hopeless romantic, this idea that she's had a lot of challenges with previous boyfriends. She sings about the challenges that she's experienced in the music industry. For example, the situation with Kanye West, the situation with Scooter Braun, all of these things are manifested in her music. And looking at that from a fan's perspective, we feel like we know who Taylor Swift is. We feel that we also feel the emotions that she goes through. We also think that we understand who she is, what she's been through, and why she behaves in the way that she does. So we feel sympathetic, we feel empathetic, we're happy to support the music in that way. So one example that I think is really, really sort of prevalent in this context is, and we've looked at it in the first presentation by Prof. Landy, in terms of the re-recordings. Imagine Taylor Swift was able to get millions of people to buy or stream the exact same music that they already owned at one point, right? So for the Taylor's version, she convinced the fan base, among others, that we shouldn't listen to the original recordings anymore because this is hurting her in a certain way. And the entire fan base agreed. People swapped out on their iTunes and their Apple Music and their Spotify playlists, the original versions for the Taylor versions. People went out and bought the CDs and even vinyl records and things like that of the new Taylor versions. How does all of this happen? This really only happens because fans feel invested in Taylor Swift. And from that investment in the music, we see the investment coming out in the secondary IP portfolio in terms of the trademarks. So when we talk about trademarks, and Prof. Dixon spoke really well about this, exposing the range of trademarks that she has. So from the album titles, song lyrics, even though we'll talk about the song lyrics in a little bit more detail shortly, because of the impact of the parasocial relationship. And I really do think that Taylor Swift acknowledging that this was an unpopular move is demonstrating the bidirectional parasocial relationship. She fed off of what the fans were saying, fed off of what the public was saying, and altered her strategy for trademark. But when we talk about trademarks, we're really focusing on the idea that trademarks are symbols and that trademarks have this communicative function. So when you see the trademark, you don't just know where the goods are coming from. You don't just expect the quality of the goods, but the trademarks also tell you a story about those goods themselves. So whether we're talking merchandising, we're talking advertisements for the albums or the tours or whatever the case is. When you see Taylor Swift's name, when you see Taylor Swift lyrics, when you see other motifs and signs that are attributed to Taylor Swift, again, you get a particular meaning, you get a particular value coming from it. And again, that's where the bidirectional parasocial relationship is particularly important. So if you think about those friendship bracelets, what are the common things on them? The name, obviously Taylor Swift, the name, Swiftie, her album lyrics, the names of her albums, different catchphrases that she uses, the names of her cats, all things that either are trademarked or would have been trademarked at some point potentially. And the fact that we get the fans leading the charge with the advertising in this way is again great evidence of the existence of this parasocial relationship. They don't need to be prompted to throw everything Taylor Swift out to the public. So Taylor Swift in this way does not really have to work hard or spend extra money on marketing because her fans are doing the job for her. But again, this all sort of hinges on the fact that the fans think that they know Taylor Swift. The fans think that they understand what she's about, what she means, and we get that from the music. In the music themselves, they're also what we call Easter eggs. So these little sort of hidden gems or secrets that she's engaging with the fans to try and figure out and learn more about her. So it feels as though we're playing a game with her, learning more about her as we go along, and also contributing to that feedback loop. Yeah. So all of this is really is tied together by the fact that Taylor Swift also has right of publicity or persona rights. And by having persona rights, she's really embodied herself in all of these things that she has. So all of her IP really exudes Taylor Swift. There's a very clear Taylor Swift aesthetic. And again, coming back to these ideas of like, the hopeless romantic, the underappreciated female, these sort of things all come out in her music. That's also part of her image. And she protects this really well. So where she chooses to maybe allow fans to do fan fiction, she allows fans to create fan-created works and things like that, is showing, again, the existence of the parasocial relationship because, yes, she can technically stop this under the law, but she's choosing not to because, again, it's serving a purpose in creating that feedback loop.
So, what we've been talking about so far is the parasocial relationship and how it has been used to generate meaning. In our research, we found that there are three fields that all talk about meaning from slightly different perspectives. So Justin already touched on trademark law. Now, historically, trademarks were used as indicators of origin, which they still are used for. Later on, in the 1930s onward, McCarthy argued that trademarks also symbolize quality. And since then, there have been different theoretical discussions about the various functions of trademark law. And the one that is most relevant to us is the communication function. So in the communication function of trademark law, signs have specific meanings, but it's more than just you are buying this product for the product. You're buying it because you want something to show your values. So you're not buying the Eras Tour merch because you need a new t-shirt. You're buying it because you want people to know that I went to this tour, I support Taylor Swift, I'm a fan. That type of theme is also present in the marketing literature and the cultural studies literature. So what was interesting to us is that these three fields all have a convergence from around the 1990s going forward with the whole concept of individuals and meaning. So the field of cultural studies actually started in the 1960s, and then at that point, rather, mass media was being examined of how they are basically gatekeepers of culture. Moving forward into the 1980s, the focus then became on cultural products. What are people consuming? But then from the 1990s onward, we had the subfield of celebrity studies, which focus on the celebrity herself or himself, the actual so-called producer of the culture. And again, we see here, similar to the communicative function of trademarks, people who are supporting this celebrity are buying this merch or listening to the music or buying the extra music that they already had because they like the celebrity. They want to align with the celebrity, and they also want to join a group of like-minded people. So being part of a fandom is being part of a community. You have people who have similar thoughts to you, and it kind of validates your own feelings towards this person. Similarly, in marketing literature, in 1989, there was a famous article that came out by McCracken on celebrities as endorsers. Now, celebrities had been used in the marketing industry for quite a long time, from the 1900s, but they really became very much entrenched from the 1990s onwards as just a par for the course celebrities work in marketing. So in terms of the type of celebrity marketing, we started off with endorsement marketing, where the celebrity is using this product. So Taylor Swift drinks Diet Coke, therefore I want to drink that too because she thinks it's a good product. She has good values, good taste in my book, so I think she must think this is nice. I want this product too. But then we evolved more to lifestyle marketing. So rather than focusing on the product itself, we're saying if you buy this product or use this service, your life is now closer to the celebrity's life. So we see this a lot when celebrities, and this is not specifically a Taylor Swift example, but celebrities are mentioning brands in their songs. Those mentions are often paid because you want now what the celebrity has. We also then have the evolution of the human brand. So the celebrity herself is a brand at this point, and she knows that she is curating her image for sale. Because again, the more value that is put in, the more value that is taken out, the more financial return you're going to get. So all this would not have been possible if Taylor Swift did not put in the groundwork. She's reached the point now where the fans are basically doing the work for her. Even if you're not a Taylor Swift fan and you're here today, you might know somebody who likes Taylor Swift and they told you the album was coming out, Life of a Showgirl. Or if you haven't heard yet, this weekend they're going to tell you which song they like. So the fans are actually doing the marketing. And this is because Taylor Swift put in that groundwork and is now reaping the rewards. In the early days, she used to use MySpace. When we got other social media, she used to direct message fans. She used to post photographs of herself baking cookies with her cats. And we know that cats became a very big thing in the trademark world. She used to even have secret sessions, listening sessions of new albums back in the day with the fans selected for this purpose. And while she doesn't do this much social media as these days as she did in the beginning, she still once in a while posts things on her TikTok. She posted a video of her dad on a Segway behind stage. She posted another video of her in a club with her parents with the caption talking about her friend told her to bring her parents. And you can imagine that was not necessarily the best move, but it was funny and it made her seem real. And all these things led to the value of her intellectual property rights really increasing. So I'm going to hand over to Justin to conclude on how this bidirectional power social relationship really has made her IP extremely valuable.
So in the paper that we wrote, what we found is that, or let me say this differently. When we started writing the paper and we wanted to latch on to this idea of the parasocial relationship, what we found was the sort of bottom line denominator is this concept of meaning, that if you want to really exploit your intellectual property portfolio to the fullest value, you need to have this underlying meaning that people buy into. So where you have this bidirectional parasocial relationship coming into play, that people buy into the meaning, they internalize that meaning, you're more than likely going to be able to sell them your products in a lot easier way, and they're going to consume it and get increasing value from it. So when we looked at these different fields, cultural studies, marketing, and trademarks, what you find happening is that meaning is the underlying concept common to all of these fields. So when you look at cultural studies, the idea is that celebrities have meaning beyond just the content that they produce. They're not just a singer, they're not just an actor, they're not an athlete or whatever the case is, but rather they produce meaning, and that meaning has value to their fans. Similarly, in marketing, the idea is that you're selling an experience. And again, the experience has a particular meaning to it. People want to do something or they want to buy something because of how it makes them feel. You're not just selling a product. Brands like Nike in particular learned about this in the 1980s when they pivoted from trying to sell products to trying to sell an experience. Taylor Swift has done the exact same thing. Going to the Era store is not even so much about hearing the music, though that's fantastic, and Taylor herself is fantastic, but it's about being in the atmosphere and the environment of a Taylor Swift concert. That is an experience in itself. Akin to maybe going to a football match with your favorite team, that sort of feeling and recreation is really now starting to go mainstream. You saw Harry Styles, you saw Pitbull, the marketing of their concerts and their fandom are doing similar things to what Taylor Swift did for the Era store. And then in trademarks, we spoke about this idea of the communication function. The idea behind trademarks ultimately is that symbols and signs and marks have meaning. And the user, sorry, not the user, the fans, sort of drawing from the user of the trademark, Taylor Swift in this case, they begin to use those trademarks as a badge of allegiance. So they wear them very strongly, very proudly. They want people to identify them as Swifties. They want to identify with other Swifties. So again, they are doing the communicative work to get Taylor Swift's trademarks in different places that it ordinarily wouldn't be, but for this parasocial relationship. So the bidirectional parasocial relationship is really something that, as we use in the term in the paper, leveraged. Taylor Swift has leveraged this bidirectional parasocial relationship to really get full value for her intellectual property portfolio.
All right, so that brings us to the end of the last presentation. So let me just switch over to the chat. Okay, so this is the time for final questions. So if you have any questions, let us know. In the meantime, I would ask Dr. Koo, in terms of research, because we looked at different fields and we are both IP people, what would you describe the difficulties of conducting interdisciplinary research to be? So just a general research question.
Yeah, I think the first big challenge in conducting interdisciplinary research is trying to acclimatize the different ways literature is written. In particular, looking at the marketing research, their writing style and their writing format is very different from law. So just trying to figure out how they get the information is something that's a challenge. Because sometimes they make claims and then they don't necessarily back it up like we do in the law. So I think that's something, speaking from a law person perspective, that we have to evidence every point we make. That's not necessarily the case in the marketing literature. So sometimes you have to dig really deep to find the footnotes to support what it is they're saying if we want to take that and use that in an argument. So that's something to be mindful of. Because again, we have to produce a paper that's well evidenced. In terms of cultural studies discussions, I think their focus is less analytical and more descriptive as to the process that takes place. So it's a different type of analysis. And again, being able to take that information and put it into a law context, you have to recontextualize it a little bit. So that was a little bit of a learning curve for me. I will say that when we did this paper, when we got the first round of edits from the publisher, a lot of it was in the other disciplines. You need to explain this a bit more. You need to defend this a bit more. And again, we had to then go and think of creative ways to bring that into the fold of the legal discussion.
Okay, so I'm not seeing any other questions in the chat. So I just want to tell everyone, thank you so much for coming out. I must say special thanks to Professor Landy and Professor Dixon. Both of them responded very quickly when I asked if they would do this presentation, which is always great when you're planning an event, for people to say yes up front. So very much appreciated their presentations, which I think we all rather learned a lot from both of these very well thought out presentations. Thank you, Dr. Koo, as well, for also agreeing, which I had kind of signed him up for this, but as he is my colleague, I figured he would be in support of this faculty event. And thank you all for being an engaging audience. We hope you learned a lot. And I hope everyone is taking the time to now think about all those Taylor Swift songs now that Life of a Showgirl is out. There is so much IP behind Taylor Swift, and she really has leveraged that parasocial relationship to a real extreme level in a very positive way, to the point that we feel as though we can somehow relate to a multi-millionaire because she gets us, which is truly a feat of really taking in meaning and using it to your advantage. And she's coming across very relatable in all the social media interviews this week. The Jimmy Fallon interview, there was a few out this week, and I thought, yeah, she's just like me. And yet that is obviously not the case, but fantastic job to Taylor Swift. And thank you to her for creating all this great IP for us to talk about today. So thank you everyone for coming, and look out for the recording on the faculty's YouTube page. Have a great day, everyone.